Our guest today is Janice Payne. Janice is a partner at the prestigious law firm of Neelan, O'Brien and Payne. She provides advice and services to employees and employer clients in all employment-related matters and deals extensively with both the public sector as well as the private sector. Under Janice's leadership, her firm was appointed as representative counsel for large groups of non-unionized employees in solvency matters, notably Nortel and CanWest. Janice represented Canada's Inuit in the residential school settlement negotiations and in the proceedings before the courts across Canada to clarify the class action and to approve the settlement. In 2001, our guest was honored for her pioneer role in the legal profession by the Women's Law Association of Ontario, in recognition of her contributions to law, women in the profession, and to the community. In 2008, our guest was awarded the Businesswoman of the Year, professional category by the Women's Business Network. Janice was also selected by her peers as one of the best lawyers in Canada in labor and employment law. In 2013, the Canadian Legal Expert Directory, as well as the 2014 American Lawyer Guides, had named her as one of the top lawyers in Canada. In 2012, Janice was awarded the prestigious Diamond Jubilee Medal and was inducted into the Wall of Honor by the University of Ottawa. She's a former member of the Board of Directors and past president of the Ottawa Chamber of Music Society and is a current member of the Board of Directors of the National Youth Orchestra of Canada. More recently, our guest has been participating in initiatives to raise awareness of mental health, joining Women for Mental Health, a program of the Royal Ottawa Foundation. She has also been appointed to serve as a member of the Board of Governors of the Community Foundation of Ottawa. Welcome, Janice, to the Ryerson Negotiation Project.
Thank you, and thank you for having me. This is going to be fun.
Now, you've been involved in employment-related matters for a good number of years. And I want to ask that question as I ask all of our guests. What's the norm in terms of your preparation for representing various clients, whether they be on the employee side or indeed on the employer side?
A key part of the preparation is to understand the goals and objectives of your client. Even clients apparently dealing with the same fact situation will not necessarily be in the same place in terms of what they want to achieve, their tolerance for protracted dispute, their interest in getting a matter resolved quickly. That varies from client to client. So to sit down, talk to the client, understand where they are at, and then go into the negotiation with a thorough file review and a checklist of items to cover to make sure you don't miss things.
When you say a checklist now, is this done per client basis, or is it a generic checklist that you use for most of your clients?
No, it's probably, the generic one I probably carry around in my head and then adapt that to the particular client's circumstances.
In terms of moving forward, where do you put relationships in terms of the negotiating process?
It's one of the things you do before embarking on the negotiation. It's easier to do now, of course, with the internet. Is try to get some sense of the opposing party, the opposing lawyer in my case, and spend some time perhaps talking to your client about where they're coming from, what their objectives are likely to be. If you have a pre-existing relationship, particularly with counsel on the other side, and if that relationship is positive, you can probably get into a meaningful negotiation faster, get to the point faster, get the matter resolved faster. It can be really important. By the same token, if you know you're dealing with somebody difficult, you probably don't waste as much time trying to resolve the thing as you did the first time you dealt with that individual, and then jumpstart into perhaps a more adversarial process if that's what you know you need to do to get to a result.
So in your style of negotiations, how would you describe your communication style? Are you more inclined to pick up the phone? Is it a lengthy letter? Is it a combination of short, succinct emails, texts? How do you operate, and what do you find to be the most effective from your perspective?
In my practice, it's really very rare that I would avoid setting out my client's position in a letter. It does not need to go on for pages and pages, but you need to let the other side know where you're coming from and what matters to you and why. I'm often talking to the client when I'm doing that on the other side of the table so that they understand. I'm perhaps pushing buttons that I know will be meaningful to that client. Until you do that and give the client on the other side something to bite on, something to think about, maybe worry about, it can be difficult to get a good negotiation going. There are one or two lawyers in town that I will phone without sending a more detailed letter, but that's rare. It's very rare. I find I need to set the stage that way. And then after that, we can get into phone calls, email, communications without, and drop the letters.
Do you find, for instance, that opposing counsel in the negotiations will respond to your letter with either their list or responding to your concerns?
They absolutely will respond. And one of the things we need to learn when we read those responses is not to take them too literally, because what both parties have done is driven stakes in the ground and positioned themselves. The number of times that I've had a response saying, no, get lost, not interested in talking to you, absolutely not. And I've thought, remember, pick up the phone. And that's when you pick up the phone and say, well, now, where are we going with this? Do I really need to issue a claim? Well, Janice, here's the problem. And a lawyer will often talk much more revealingly on the telephone, particularly if you remember to stay quiet and listen for what you're going to hear. And often there's all sorts of middle ground, but there's just been this positioning in the correspondence. So you can't take the correspondence too literally. It does set the stage. It is important.
Would you deem that exchange of those first round of letters as the agenda for the negotiations?
Absolutely. Absolutely. It is the agenda. Now, that agenda may evolve. And again, in my area of practice, what I find is that my client changes his or her mind in terms of, at one point the objectives are these, and then things start to shift. My negotiations are usually around employment. Maybe my client is starting to feel better about his situation. Maybe there's a job looming, and the thing starts to change. Really important in any negotiation process where you're acting for somebody to stay on top of where that somebody is and what is now mattering to him, whether his or her situation has changed in a way that will really affect what you're doing with the negotiation.
Would you copy, for instance, that initial letter that you send to the other side? Mm-hmm. Would you share that with the client?
Always. I always write the letter myself and send it to the client, and I say, review it, make sure it's correct, first of all, because after all, I didn't live the story, he or she did. So please check it for accuracy. We don't want to be embarrassed by a letter that has misstated things. And make sure I've captured what you want me to do. I always make it very clear to the client, I want your input. I'm not going to be bothered by it. That's why I do it. I always do it like this. And so it will go back and forth. Sometimes it's not revised, but more typically it will be edited and go back and forth a bit, and I get the client's buy-in on what I'm doing. I think that's important.
That's really a clarification of the mandate.
Absolutely.
That you have. It's now in writing, they've reviewed it, they've tweaked it.
That's right.
They understand, and if there's anything to be added, they'll certainly bring it to your attention.
That's right.
And now, what's been your experience with that? Have you found that clients like that? Do they find it to be refreshing that I've spoken with my negotiator, my counsel, and she has now been able to put pen on the paper and
Yes, they like it. They're always pleased when they see I've been able to capture a lot of what I've been told. They like that and are reassured by it. But it would be rare for a client to be bothered about having a chance to check it over and make corrections. I do find I need to tell the client at the beginning that I expect that I want it, and that they mustn't feel uncomfortable with presuming to correct my letter when it's their story, I'm telling.
Have you ever gone to the bargaining table after going through this process?
Yes.
And found that your mandate is changing very quickly because of facts either you didn't know or your client didn't know?
And that happens all the time in mediation. It's become so popular now with legal disputes, whether they're in litigation or not yet. If the initial efforts to settle fail through correspondence and phone calls, to move into a mediation process with a neutral. We do that more and more frequently with all kinds of disputes now. If the matter's in litigation, the mediation is quite early in the process typically. At that point, everybody's in the room, and the parties always go into that exercise with a gap in their position, sometimes a very big gap and a very different view of the facts that have brought them to the table. Looking across the table at each other, talking to each other about it, either directly or through the lawyers, really does have an almost magical effect in terms of changing ideas on both sides of the table.
Do you find that things have changed somewhat in the law and that clients now want you to deliver on what you've actually said, either in your retainer letter or in your revised letter of the issues? Are they becoming more sticklers, if you will, in terms of?
Yes, I think they are. They're better informed, and the internet again is responsible for that. And the knowledge level of people out there is high. I'm remembering one matter I'm handling now where the client is doing his own legal research. He's a bright individual. He's doing his own research, and he's just sure that I may not be quite right in some of these areas and needs to have some discussion about that. So there are more challenges. Clients are better informed. It's in the same way that we deal with our doctors now. We don't necessarily just take at face value what we're told.
So let's assume you have a case, you have a client, it's a dispute in relation to employment. You've covered off all of the issues, you've forwarded the letter to the client and now to the other side. When do you entertain the aspect of other options? Do you entertain that aspect of other options early in the process, or do you wait for a period of time in the negotiations before you would introduce those?
With my client, I will have discussed other options right at the beginning. With my client, I will have told the client, this is the likely result, the fair result if we took this matter forward. These are the different paths you could go down depending on what matters to you. But we'll go in with a letter that leaves us negotiating room. So the client knows that the initial letter is not a bottom line position. The initial letter is one that is designed to enable us to move towards a solution that will make sense. So that conversation's happened very early with my client. With opposing counsel, I've delivered typically at that point a position, and I need a response back from the opposing lawyer before I will move or suggest that my client move. Sometimes that's hard to get. Sometimes that needs the phone call. Most lawyers understand that we will not bid against ourselves, that it's necessary to make some movement in order to keep the dialogue going. But sometimes getting that movement can take some creativity.
You mentioned earlier in your introduction about listening skills. Any comments you'd like to make on that in terms of how important they are? And have you always been a good listener, or is it a skill you've acquired?
No, I tend to be someone who likes to talk. It is so important to know when to stop talking. In a difficult discussion, just stopping and not offering anything and letting the pause build will be enough to prompt the other side to begin to talk and perhaps give you what you need in order to advance the discussion. It is probably one of the most important skills in any negotiation is to know when to stop talking and listen to what you're hearing. That will also help you identify needs in the other camp that perhaps can be addressed, perhaps aren't even terribly significant to your own client. So just really an important part of the exercise and something that I learned after doing this for a while.
It's a skill that you've acquired.
Yeah, through practice.
Tell us about multi-party negotiations. You've been involved in a few of those kinds of things. Any particular protocols or do's and don'ts that you could share with us?
It usually, from my point of view or the point of view of my client, if I'm dealing with multiple parties on the other side, I don't much care who pays, as an example, as long as collectively we get to a result that will be comfortable for my client. Sometimes there's an individual involved in the discussion that you can relate to more effectively, that you can communicate with more effectively, so you watch for that. Sometimes you can, through a conversation like that, get the discussion going over there and just pull back a bit. Let them work it out. You don't need to tell them how to share the responsibility, but you expect them to work it out. So as with any negotiation, you watch and look for the people you can talk to. Engaging a mediator in a process like that can be enormously helpful. And the private discussions with the mediator, in terms of feeding that individual ideas that he or she can take back to the other parties, or one of the other parties, can be very effective.
If we just exclude the mediator for a time, what is your take in terms of how you share information in a multi-party negotiation? I mean, you're really acting as an agent for your client, principal-agent relationship. And then there are other stakeholders. But
that's right. You must be accurate and honest in the way that you share information. That doesn't mean you have to give away the store. That doesn't mean you have to tell everything about your client to the other side. But what you do decide to say must be accurate, or it can impair the whole result. And it won't necessarily be the same thing to all of the parties, depending upon what level of cooperation or assistance you might need from one versus the other. In negotiations I handle, it's more typical that opposing parties, even if there are multiple parties, will be aligned sometimes with one counsel, but not always. I can think of several on my desk right now where I'm dealing with multiple parties in different counsel, and it is a challenge. It does add to the time involved in getting the dispute resolved and the complexity, the discussions that need to happen. Sometimes it's possible to settle with one side fully and leave the others to just work out the rest of it.
How do you anticipate the significance that the other side gives to the importance of time? If you and I are in a negotiation and I tell you, look, I want to get this done by the end of the week, you then know that I've got a time frame. But do you find that in your negotiations it becomes pretty apparent in the process that we've either got a short time or they're just going to string this out forever?
Yeah, that becomes pretty clear. A party lowballing you and refusing to move meaningfully probably isn't in any sort of a rush. I find, just as a matter of practice, every calendar year as we approach the end of the year, all of a sudden parties that weren't interested in talking to me at all are interested. And you know that a tax concern is probably driving the matter, or financial statements. So there can be clues like that. Every December is always wildly busy in my office. People I just haven't heard from in 6 months need to get their deal done. And you know, aha, I've now got an opportunity. And of course, you can make that work for you.